is a short overview of the history of women in legal practice in Australia. The early days of women seeking admission to legal practice in Australia were the subject of many of the so-called persons cases. The persons cases were called that because, rather infamously, they construed the word person in legislation to exclude women. In the other history video, I've already mentioned the case of ex parte Ogden. In Ogden, what had occurred was that Ogden was seeking election to a municipal government, that is a local council style government. He was only a few votes ahead of his opposition, who then brought an action to have several voters disqualified, and thereby, if that didn't leave Ogden with a clear win, it meant that there had to be a new election. One of those people whose vote was challenged was a woman who met the Municipalities Act definition for a voter, that is a person over the age of majority, which was 21, who owned certain types of property. However, the New South Wales Supreme Court in that case said that where it talked about a person being over the age of majority and having property, that obviously, according to them, did not include a married woman, because a married woman was not a separate legal person. Under the law of coverture, she had lost her legal separation from her husband and could not be counted as a person for the purpose of the Act. That, of course, was changed in the early 1900s when women succeeded in achieving voting rights in New South Wales. However, there is a line of cases that progressed from that, some of which discussed potential legal practitioners. So in Western Australia, Edith Haynes sought admission to legal practice, and the Supreme Court had to decide whether she was eligible. And in the Legal Practitioners Act 1893, they talked about every person who met certain educational requirements having the ability to be admitted as a practitioner of the Supreme Court of Western Australia. However, in 1904, the Western Australian Court said that the legislature could not have intended that to be such a radical change as to allow women to apply for admission to legal practice, that where person was used in that case without any clear indication that they were changing the previous situation in the law, that is that only men could be admitted to legal practice, they must not have intended for person to actually mean person, they must have intended it to mean man, and therefore a woman was not a person under the legislation. In South Australia, in 1920, there was a similar case brought in re Kitson. Kitson, once again, was seeking admission, this time as a public notary, a form of legal practitioner. And Section 26 of the Act Interpretations Act was part of her argument. In the Public Notaries Act, they talk about every person who sought admission as a public notary. And Section 26 of the Acts Interpretation Act 1915, South Australia, provided, similarly to how such acts provide today, that he includes she, and other forms of the masculine pronoun include the feminine. So they were basically saying wherever legislation used a gendered term, it included, in that case, what they assumed to be the only other gender. Now we use slightly more progressive terms. His included her, and person included both men and women. But the court said that using the word person to include both men and women in the Public Notaries Act would be, again, a fundamental change to the law and must be inconsistent with the object and intention of the Act, which was to allow for the admission of public notaries, who up until that point had only been men, and therefore the court reasoned the legislature intended person again to mean man. So women were literally being defined by our courts into the early 20th century as not persons. That, however, was changed after substantial debate in the Sex Disqualification Removal Act. That is an act removing disqualification on the basis of being female from admission to law and several other professions. And that occurred in 1921. But it was very hard fought. It was not an easy situation. So these are the for and against arguments coming from Portia's Place, which is one of the readings I've provided for you if you're interested. One of the pro women lawyers, parliamentarians, was B.A. Maldon, who said that while effectively, you can read this for yourself, but while there were matters which were dealt with by the court which were inconsistent with the modesty of women, women of course wouldn't have to do such types of law. They could take up phases of legal work that were appropriate to them, and thought that things so radical as a name of a firm being Smith and Wife or Brown and Daughter may happen in the future. He even summed up his argument as, like chips in porridge, they won't do much harm. Effectively, it's somewhere they don't belong, but they can't hurt anything. Such a ringing endorsement, however, did win the case. Against that, J. Lewis was arguing that women should not be female legal practitioners, because while there, as others were arguing, there were female doctors, and he said that yes, a female doctor could attend to ladies only, but it wasn't always palatable to women to listen to what took place in courts of law, and therefore it would ruin their innate femininity. He said that they often ask for things that ought not to be granted to them, that members of Parliament, as members of the stronger sex, ought to protect the women. Now remember, of course, at that time Parliament was completely only had male members. So he's arguing that effectively women are somewhat childlike, and like a parent they should be refused the treat that they want. And he said the bill, that is the bill to allow women to practice law, was not necessary and would not tend to bring women up in the way they should go, but would tend to do away with the sweetness, gentleness and kindness which they should possess, and that they would be far better looking after a house than agitating and pleading in courts of law. Obviously he lost, and people like me have been admitted, and many of us have been admitted since then. Here's a quick overview of the women who were admitted and some of the groundbreaking early female lawyers in Australia. In 1897, the first woman to enrol as a law student was Florence Greig. She was admitted as the first female lawyer, but doesn't appear to have practiced. In Queensland, there was an enabling act in 1905 which allowed women to be admitted as legal practitioners. Agnes McWhinney was the first woman admitted as a lawyer in Queensland. And if you are a member of Queensland Women Lawyers, you'll notice that they have a prize named after her, and one also named after Una Prentice. With Agnes McWhinney, she took the route not of going to university, but the alternative route to practice law, which was available actually up until the early 1990s, which was doing a 5-year program of articles, which was accompanied by readings and exams. And she did those articles with her father's firm, starting in 1910. She was admitted to practice law in 1915 and then went to work with her father's firm, where they actually paid her the same amount as the teenage office boy who was effectively an errand runner, go and buy some papers, etc. and rather than paying her anything similar at all to what the men in the firm were being paid, she was basically paid at the lowest level possible in that firm. However, she was stubborn, and she actually agitated with her father and brothers to be given a better wage, and they caved in eventually. The first woman to actually go to a law school and study law in Queensland was Una Prentice. She was the first woman law graduate at University of Queensland. Note that for many years until 1977, the University of Queensland was actually the only law school in Queensland. It was then followed by QUT, then Griffith, and as you know now we have James Cook, University of South East Queensland, etc., also offering law degrees. So Una Prentice was the first woman law graduate. She was actually the first woman admitted to the practice of law and admitted to the bar of the Queensland Supreme Court, so admitted as a barrister. Agnes McWhinney was admitted as a solicitor. It used to be that you were admitted as one or the other. You were not admitted back then as a legal practitioner, but as a solicitor or as a barrister. Una Prentice was also the first woman in Australia to be admitted to the bar of the High Court of Australia, and she was the first female prosecutor. She actually started working for the Commonwealth Crown Solicitor's Office during the Second World War, and she was the first woman who worked there and as a prosecutor there. And they actually had no idea how to pay her. It was so mind-blowing to them that a woman was working there as a lawyer. They didn't think that the standard rates of pay for lawyers would apply to her. And she was actually paid as a typist rather than as a lawyer. My understanding is that after the war, she moved out of legal practice, and there are a few records of what happened after that. What about women as judges in Australia? The first woman Supreme Court judge in all of Australia was surprisingly early in 1965. Roma Mitchell, who became Dame Roma Mitchell, was a Supreme Court judge in South Australia for a very long time. She was also one of the first female parliamentarians in Australia, one of the earliest female parliamentarians in South Australia. In Queensland, we lagged almost 30 years behind. The first person who was a judicial officer who was a woman in Queensland was Margaret White, who had an older title, Master of the Supreme Court. The Masters of the Supreme Court were effectively judicial registrars. They were doing the judicial part and the decision-making part of what is now the registrar's job. The registrar back then was a purely administrative job rather than a quasi-judicial job. Justice White was promoted to become a full Supreme Court judge in 1992, followed soon after by a number of other female judges. Our first district court judge was Margaret McMurdo, yes, the one who became the Chief Judge of Queensland, Chief Justice of Queensland sometime after that. The first female judge of the High Court of Australia was Justice Mary Gaudron, who was appointed in 1987. And the first female Chief Justice of the High Court of Australia was only appointed in 2017, and that was Susan Kiefel. Chief Justice Kiefel is quite the trailblazer because she was also the first female QC in Queensland in 1987. So at the time that was considered quite revolutionary that someone was appointed to become a QC who was female. And another one which is interesting for those who are interested in my sort of profession, being an academic, was that the first time a woman was appointed full-time as a law lecturer was Carmel MacDonald, who was appointed in 1976. At that time to the University of Queensland, she later became a QUT lecturer, and I actually had her as one of my lecturers when I was a student, and she was amazing. So that's a potted history of women in law in Australia, focusing on Queensland. As you can see, in the last 30 years, we've come a really long way, and none of us would blink twice at having a female judge, senior female lawyers in firms and at the bar. But that is a relatively recent thing, happening only over the last 3 or 4 decades. So that's it for our history of women in law. If you're interested, there are many histories and readings that you can look at for more information.